Monday. Bishop on Air, live with you here on a Monday morning. And just so everybody knows, the cable guy came on Friday afternoon. And interesting to say, he instantly knew what was going on. We'll see if that indeed is what happened. But appreciate Eric coming out from the cable company and setting it straight, so hopefully we don't have any drops today. But he came in and looked at the modem, and then he noticed that the modem, from the modem to the cable, there was a splitter in between. And for whatever reason, we had that splitter feeding an old 1980s original Nintendo Entertainment System box that goes into the TV, right? We had that plugged into the antenna for whatever reason. He said that could be sending errant messages, triggering the modem to flip off. So I don't know. We removed that. He checked the other cable, and so far so good. So we'll see. All right. When 8 o'clock rolls around, if we're still live, we'll see if it switches off again. But I appreciate you guys being here. Everybody chiming in into the live chat. Tons to get to this morning. We've got two different filings in the Southern District of Illinois federal courts, with the Wednesday scheduling conference going to be taking place in the challenge against Illinois' gun and magazine ban. We'll review what the state had to say in response to the Fifth Amendment arguments being made in the Langley case. And the Langley case is just one of four consolidated cases in the Southern District underneath the Barnett case. So that's one filing we'll review, but also we got to take a look at the, roadmap, the cliff notes that Judge Stephen McGlinn laid out for the plaintiffs and the defendants, and what exactly they're going to be looking at when they're dealing with the merits of this case on an expedited fashion. So we'll touch on that. Also, we got to talk about the latest across the states, from Chicago violence to East St. Louis violence and everything in between with the migrant crisis, and even bring Chicago home. An ordinance to look to increase taxes in the city of Chicago being knocked off the ballot by a Cook County judge. So we'll take a look at some of that as well. All right, it's all here with Bishop on Air. I'm Greg Bishop. Thanks for hanging out with me each and every weekday morning as we broadcast from my home studio. It's just me hanging out with you guys. All right, taking a look at some of these headlines. So I appreciate you being here each and every weekday morning here with Bishop on Air. Wednesday, in federal court, Judge Stephen McGlinn will be meeting with plaintiffs' attorneys to discuss the trajectory of the case, and some interesting things being brought up in a roadmap that McGlinn's offering up to deal with these specific issues. The weaponry in question is an item an ordinary person would keep at home for the purpose of self-defense. The weaponry in question is not exclusively or predominantly useful in military service, and the weaponry in question is not possessed for unlawful purposes. Those are just some of the questions that Judge Stephen McGlinn says need to be addressed in the case challenging Illinois' gun and magazine ban. Welcome back, Bishop on Air. I'm here with you each and every weekday morning. We've been tracking the litigation against Illinois' gun and magazine ban since the ban was put into place January of 2023, and all win on the case. So you had McGlinn issue that preliminary injunction and 6 days of an injunction against the state from enforcing the law until the state went to the Seventh Circuit and asked for a stay, essentially not letting McGlinn's injunction go into place. So then, obviously, you had this continued back and forth, going all the way up to the U.S. Supreme Court even, but a full record wasn't made. So now it's back to the district court, where Judge McGlinn is moving forward in an expedited fashion. And we've got a status hearing on the 28th. That's Wednesday. Still got to double check to see if that's going to be an open court, or if I'm going to be able to tune in via phone, or if it's a closed court scheduling conference with the plaintiff's attorneys. But we've been tracking this all the way up to this point, and on Friday, Judge Stephen McGlinn, he issued an order in that Southern District case. So let's go ahead and take a look at this together as we review the 16 pages that Judge Stephen McGlinn issued in this order. So we'll just kind of read through this, and you can follow along. In order to address potential confusion, the court issues the following order to clearly lay out the path forward in this litigation and advancing the scheduling conference on Wednesday, the 28th. The court first notes that the parties may offer any relevant evidence and advance any arguments as to any relevant issue in litigation. The judge then goes on to talk about the case is a constitutional challenge against the Protect Illinois Communities Act. The plaintiffs in this action argue that PICA is unconstitutional under the 2nd, 5th, and 14th Amendment. The focus of this order will be the Second Amendment claims. The Supreme Court has provided guidance on how Second Amendment cases should be analyzed via a one-step historical test. All right. The Seventh Circuit has stated that their pre-existing test from Friedman v. Circuit City of Highland Park is consonant with Bruin's historical test because it was not explicitly abrogated by Bruin. So the Seventh Circuit, Judge McGlinn saying, is looking at things that they say that the Bruin court did not reverse. So McGlinn continues on here. He says that Bruin ruled the government must affirmatively prove that its firearm regulation is part of the historical tradition that delimit the outer bounds of the right to keep and bear arms. Moreover, two of the relevant metrics are how and why regulations burden a law-abiding citizen's right to armed self-defense. The Supreme Court emphasized in Bruin that Heller previously determined that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. Importantly, when considering weapons that were banned at the time of the founding, quote, even these colonial laws prohibited the carrying of handguns because they were considered dangerous and unusual weapons in the 1690s. They provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. The Second Amendment does not preclude restrictions or the outright prohibition of weapons that are dangerous and unusual, in quotes. Therefore, the Second Amendment protects weapons that are in common use, as long as they are not dangerous and unusual. Put another way, McGlinn wrote, weapons that fit into common use category and not into the dangerous and unusual category cannot be proscribed by the federal or state governments. Proscribed means to regulate, to limit, to ban. Additionally, the Supreme Court stated that the definition of bear naturally encompasses public carry because most gun owners do not wear a holstered pistol at their hip in the bedroom or while sitting at the dinner table. Although individuals often keep firearms in their home at the ready for self-defense, most do not bear, i.e. carry, them in the home beyond moments of actual confrontation. To confine the right to bear arms to the home would nullify half of the Second Amendment's operative protections. As the need for armed self-defense is perhaps most acute in the home, we did not suggest that the need was insufficient elsewhere because many Americans hazard great danger outside the home more so than in it, he wrote. The Seventh Circuit contends that Friedman, and again, this is the Seventh Circuit. He's reviewing what they had to say in the case Friedman versus and Beavis versus Naperville, do not suffer from Bruin's instruction that any two-step test is one step too many. The circuit adopts a scheme in which, prior to conducting any Second Amendment analysis as to a weapon, attachment, or magazine, the court must first determine if the item in question constitutes an arm for the purpose of Second Amendment. See Beavis. If the item does not, then the Seventh Circuit holds that the Second Amendment has nothing to say about a law banning and restricting it. This method is required even if the item otherwise falls within the definition of what constitutes an arm, as set out in Heller and Bruin. The Seventh Circuit contends that this pre-certification process renders Friedman consistent with the methodology approved in Bruin that they employed in Beavis. This court is tasked with determining whether the plaintiffs are entitled to declaratory and equitable relief they seek, specifically that Illinois be enjoined from enforcing the provisions of PICA due to their unconstitutionality. In Friedman and Beavis, the Seventh Circuit has come at the question from a different direction than that was utilized by the Supreme Court in Bruin. As will be more fully explained herein, the plaintiffs should proceed in their constitutional challenge to PICA, offering evidence relevant to the tests of Heller and Bruin, as well as the tests applied in Beavis. The court is mindful that the Friedman-Beavis test manifestly shifts which party bears the burden to prove which arms are outside protection reach of the Second Amendment. Beavis requires the citizen to prove that the weapon in question are protected by the Second Amendment instead of placing the burden on the government to prove that its law banning or restricting arms is consistent with the historical tradition that delimits the outer bounds of the right to keep and bear arms. In its treatment of the banned AR-15 and any of its cousins covered in the act, the Beavis court opined that it was likely they could be banned because, based on the record before us, we are not persuaded that the AR-15 is materially different than the M16. Goes on to quote, Heller informs us that the latter weapon is not protected by the Second Amendment and therefore may be regulated or banned because it's indistinguishable from the machine gun. The AR-15 may be treated in the same manner without offending the Second Amendment, McGlinn writes, quoting Beavis. The Seventh Circuit concluded this portion of the opinion by stressing again that this is just a preliminary look at the subject, and the Second Amendment's challenge to gun regulations often require more evidence than is presented in the early phase of litigation, McGlinn quotes. Because of this, the Seventh Circuit stated that there thus will be more to come, and we do not rule out the possibility that plaintiffs will find other evidence that shows a sharper distinction between AR-15s and M16s and each one of its relatives than the present record reveals. Moreover, better data on firing rates might change the analysis of whether the AR-15 and comparable weapons fall into military or civilian side of the line. So the burdens of proof. Are the arms covered by the Second Amendment? Considering the discussion above, McGlinn writes, plaintiffs must establish that the items in question are not items that are beyond the gravitational pull of the Second Amendment. In other words, that the items are not on the wrong side of the delimits of the Second Amendment. According to the Seventh Circuit, Second Amendment protections does not embrace weapons that are exclusively or predominantly used in military service or weapons that are not possessed for lawful purposes. Such items would not trigger Second Amendment protections, even though they would otherwise clearly fit in the definition of arms as defined in Heller and reaffirmed in Bruin. So Beavis requires the plaintiffs to establish by a preponderance of the evidence that, one, the weaponry in question is an item an ordinary person would keep at home for purpose of self-defense. The weaponry in question is not exclusively or predominantly used in military service, and the weaponry in question is not possessed for unlawful purposes. And there's a footnote there, the first footnote in 6 pages. And you scroll down and it says the example given is the idea of a sawed-off shotgun. With this in mind, it appears the prong applies only to a class of arms or attachments and is not a component of the bearer's case-specific criminal intent. All right, so that's the footnote. But he goes on to say, if the plaintiffs can prove that the above 3 propositions, then the items captured by the gravitational pull of the Second Amendment, and the case ripens at the moment into a claim where the Second Amendment might have something to say about it, according to the Seventh Circuit's rationale in Friedman and Beavis. Having been captured within the Second Amendment's gravitational pull in order to land safely on terra firma, the plaintiffs need only establish by the preponderance of the evidence that arms, attachments, and or magazines are in common use for any lawful purpose and are not otherwise dangerous and unusual. If they are able to establish all of the above, the plaintiffs will have met their burden to prove that the ban on specific items in PICA violates their Second Amendment rights. Friedman and Beavis do hold that fully automatic machine guns are categorically beyond the limits of the Second Amendment protection. They reaffirm the rule of the Second Amendment does not authorize private persons to possess weapons such as machine guns and sawed-off shotguns that the governments would not expect or allow citizens to bring with them when the militia is called to service. That being said, the Seventh Circuit also acknowledges that, obviously, many weapons are dual use. Private parties have a constitutionally protected right to keep and bear them, and military provides them to its forces. In this sense, there is a thumb on the scale in favor of the Second Amendment protection. This exceptionally important clarification resolves any confusion that an arm can never enter the gravitational pull of the Second Amendment simply by virtue of the fact that the military may provide the arm or a similar arm to its forces, or they would be useful in military and law enforcement setting. Clearly, the dual purpose rule does not require arms, attachments, or magazines to be defined as either for an exclusively military purpose or for an exclusively civilian purpose. Just because an arm has a cousin in the military does not mean that the arm is beyond Second Amendment protection. The Seventh Circuit's acknowledgement of the dual purpose of the weapon could fairly be restated as follows. A civilian can have constitutionally protected right to keep and bear particular arms, attachments, or magazines, even if the military provides the same or similar arms, attachments, or magazines to its own forces, or law enforcement provides them to the officers in the arms if the arms have a dual use. Critically, the Seventh Circuit places the thumb on the scale in favor of Second Amendment protections for dual-use arms. In acknowledging the obvious, as the Circuit words it, the task at hand comes into clearer focus. It also helps chart the path for discovery in this case and more clearly fleshes out how a hearing on the merits should look. In this vein, the plaintiffs may choose to provide evidence that semi-automatic rifles, carbines, and pistol handguns, specified attachments, barrel shrouds, foregrips, flash suppressors, etc., and or magazines holding a specific number of rounds and or ammunition carrying devices are commonly held by civilians for self-defense or other lawful purposes and are not exclusively or predominantly useful in military or law enforcement context. Even if they are used by the military or by law enforcement, dual use may still be demonstrated. Once dual use is established, the scale tips towards Second Amendment protections. A. How weapons are sorted between military and civilian use. It's important to understand, McGlinn writes, that there are far more similarities than dissimilarities between military use and civilian use when it comes to specific semi-automatic fire rifles and pistols. Thus, the sorting process must necessarily be more probing and multifaceted and must consider why a citizen might select certain weapons for self-defense and the practical challenges citizens face when called upon to defend their lives. McGlinn continues, military use. The M16 and M4 are designed to be carried by members of the military. Military members utilizing M16 rifles or M4 carbines do so in specific ways, from guarding critical facilities or equipment to advancing on specific targets. Such soldiers, Marines, airmen, and sailors are deployed with various other pieces of equipment, including but not limited to Kevlar, body armor, utility uniforms, tactical boots, load-bearing vests, knives, flashlights, a radio, sidearm, copious quantities of spare ammunition, to list a few. Our troops also proceed into harm's way as a trained unit, supported by air cover, reinforcements, medical support, naval support, and reconnaissance and intelligence from human and satellite sources. In such situations, the M16 and M4 are designed to fulfill a specific niche. Their semi-automatic fire feature permits precise targeting shooting, while their ability to fire in 3-round bursts or in full auto capacity is designed to provide suppression fire in a situation where members of a squad are moving to or from an objective. Military hardware must meet the exact military specifications to fire in fully automatic capacity for a substantial period of time without failure. Civilian use. The average civilian may be called upon to defend his or her person, family, or property from an armed attack or invasion. This person is usually ambushed or is the target of a sneak attack and is stuck with the weapons he or she has readily available. The civilian may be called upon to defend others who are not armed and often will not have time to plan or regroup with other allied defenders. Combat in the home or property may draw the civilian away from ammunition supplies. The storage of arms in the household usually requires restricted access to firearms and munitions because they must be maintained under lock and key and inaccessible to children or those who might self-harm. In an emergent situation, the accuracy, safety, ease of use, and magazine capacity of an individual defense weapon may literally be the difference between life and death of the civilian and his or her family members. Thus, while both members of the military and civilians may be called upon to engage mortal combat, the civilian is often an army of one with no backup, no support, no reinforcements in the moments when the attack occurs. The life and death stakes mandates that their firearms have both lethal capabilities and give, at minimum, our citizens a fighting chance. Therefore, sorting between military use and civilian use is an exercise in understanding the complex dynamics of self-defense in which lethal force may be required to repel a rapist, a murderer, an arsonist, a kidnapper, a stalker, an armed burglar, or multiple attackers at once. Moreover, if our inquiry is fully satisfied by simply considering a self-defense scenario in which one physically fit person confronts one other person at his or her front door while armed with a pistol or a pump-action shotgun, then this case is fairly straightforward. However, if we consider only that scenario, then our search is superficial and woefully inadequate. Considering only that scenario does a great disservice to citizens who face mortal combat under very different circumstances. Unlike members of the military who must meet rigorous physical standards in order to be deployed in combat, citizens who may find themselves in a self-defense scenario may be of various ages with various ranges of physical mobility. Unlike deployed members of the military, a civilian called to defend himself or others may not be able to operate a pump-action shotgun or a pistol by reason of disability, age, or infirmity. Therefore, such considerations of physically fit individuals only would impermissibly exclude the elderly, disabled, infirmed, and others. It would also ignore the myriad challenges facing a citizen in defending himself or herself in a confrontation. Characteristics and considerations. The following non-exhaustive list of considerations may be relevant to whether or not an item has lawful purposes or falls within dual category. All right, the dual use category. So again, this is all from Judge Stephen McGlinn on Friday, issuing this order. It's 16 pages long. We've read through most of it here, but now he's going to start going through things to consider and considerations. And I want you to just kind of answer these questions yourself as you're watching. Yes or no type of questions here as you're watching these go through. So characteristics and considerations. The following non-exhaustive list of considerations may be relevant to whether or not an item has lawful purpose or falls within the dual use category. Does the